Audio's coming through great. Kylie, Sebastian, do we have the members on or can we get started? Kylie, Sebastian,
Yeah,
do we have the members
everyone
on
in
or
right
can we get
now
started?
from the attendance room. We just need like 10 seconds to start the live stream and then we're good to go.
Okay.
Kylie, Sebastian,
Yeah,
do we have the members
everyone
on
in
or
right
can we get
now
started?
from the attendance room. We just need like 10 seconds to start the live stream and then we're good to go.
Okay.
Kylie, Sebastian,
Yeah,
do we have the members
everyone
on
in
or
right
can we get
now
started?
from the attendance room. We just need like 10 seconds to start the live stream and then we're good to go.
Okay.
We're good to start.
Kylie, Sebastian,
Yeah,
do we have the members
everyone
on
in
or
right
can we get
now
started?
from the
Great.
attendance room. We just need like 10 seconds to
Well,
start.
thank
the
you
live
very
stream and then we're
much,
good to go.
and good morning. Okay. Thank you to the panelists for
We're good
joining
to
us,
start.
and I hope
Kylie, Sebastian, do we have the
today's
members on
discussion
or
is
can we
both
get started?
informative.
From the
and
attendance
supportive.
room, we just need like 10 seconds to
Well,
start.
thank
the
you
live
very
stream and
much,
we're good to go.
and good morning. Okay. Indian Child Welfare Thank you to the panelists for
we're good to
joining us,
start.
and I hope
Kylie, Sebastian, do we have the
today's
members on
discussion
or
is
can we get
both
started?
informative.
From the
Hence,
attendance
the
room, we
landmark
just need like 10
legislation
seconds
was.
to
Well,
start.
thank
the
you
live
very
stream and
much,
we're good to go.
and good morning. Strong bipartisan basis. Thank you to the panelists for
we're good to start.
Kylie, Sebastian, do we have the members on
everyone in
or
right
can we get
now
started?
from the
Hence,
attendance
the
room, we
landmark
just need
times
like 10
legislation
seconds
numbers.
to
Well,
start.
thank
the
you
live
very
stream.
much,
Children have been
and
separated
good
from
morning.
their
Strong
parents.
bipartisan basis. Thank you to the panelists for
we're good to start.
Kylie, Sebastian, do we have the members on or can we get started?
by the
From the
1970s,
attendance
the
room, we
landmark
just need
times
like 10
legislation
seconds
numbers.
to
Well,
start.
thank
the
you
live
very
stream.
much,
Children have been
and
separated
good
from
morning.
their
Strong
parents.
bipartisan basis. Thank you to the panelists for
we're good to start.
Kylie, Sebastian, do we have the members on or can we get started?
by the
From the
1970s,
attendance
the
room, we
landmark
just need
times
like 10
legislation
seconds
numbers.
to
Well,
start.
thank
the
you
live
very
stream.
much,
been separated
good
from
morning.
their
Strong
parents.
bipartisan basis. Thank you to the panelists
we're good to start.
Kylie, Sebastian, do we have the members on or can we get started?
by the 1970s, the landmark times legislation numbers. Well, thank you very much, and good morning. Strong bipartisan basis. Thank you to the panelists
we're good to start.
Kylie, Sebastian, do we have the members on or can we get started?
by the 1970s, the landmark times legislation. Well, thank you very much, and good morning. Strong bipartisan basis. Thank you to the panelists
we're good to start.
Kylie, Sebastian, do we have the members on or can we get started?
by the 1970s, the landmark times legislation. Well, thank you very much, and good morning. Strong bipartisan basis. Thank you to the panelists
we're good to start.
Kylie, Sebastian, do we have the members on or can we get started?
by the 1970s, the landmark times legislation. Well, thank you very much, and good morning. Strong successfully passed ICWA. Today, this legislation remains the gold standard of child welfare policy as it serves to center the best interest of Native children in child custody proceedings, recognizing that Native youth should remain connected to their cultures, families, and communities. ICWA sets requirements and accountability measures for state welfare courts and to adhere to accomplish this mission. ICWA not only recognizes the history of removal and genocide that followed generations of assimilationist policies, but it also supports tribal sovereignty and seeks to protect the rights of Native children. Unfortunately, ICWA is under attack today. In the past several years, anti-tribal interests have launched a series of legal challenges against it with the goal of undermining tribal sovereignty. The Brackeen versus Haaland pending in the U.S. Supreme Court is an example of that. After oral arguments last fall, we are all awaiting how the court addresses this issue. In the meantime, however, I think it's important for us to revisit ICWA and the history that brought about its passage 40 years ago. Some in Congress do not wish to conduct oversight on this topic until the pending legislation is finalized. However, this is a tremendous priority for tribal leaders and communities, and frankly, it's our job in Congress to do exactly this. With attacks on tribal sovereignty becoming more prominent in recent years, it is critical for us to respond by reaffirming the U.S. government's trust and treaty obligations. Native youth are our Indian country's future, We must stand together to protect their rights and the intent of the legislation. Today's expert panelists will share multiple perspectives regarding ICWA. We will hear from the need for ICWA, why it works in Indian country, and how Congress can better support its mission going forward. I thank you. I thank you for joining us today, and I look forward to the discussion. Now, I would like to transition to our panelists who are present today to deliver remarks. We ask that you keep your remarks to 5 minutes so that we can hear from each of you, and that members that will be joining us and have joined us will have an opportunity to discuss, ask questions, and make comments regarding your presentation. After your statements are complete, please remember to mute yourself to avoid any inadvertent background noise, and I will allow the entire panel to speak before we open it up for discussion to members or for questions. Now, I would like to recognize Mr. Jack Trope, who is Senior Director of Indian Child Welfare Programs with the Casey Family Foundation. Mr. Trope, the floor is yours.
Thank you very much, ranking member and members of the committee. It's a pleasure to be here. As you may know, Casey Family Programs is a national private operating foundation. We work in all 50 states, Puerto Rico, and District of Columbia to support child welfare systems and prevent the need for children to go into foster care. I'm in the Indian Child Welfare Unit, and we work with tribes around the country and on issues like ICWA. So the ranking member's statement almost summarized my testimony, so I appreciate that. We do have a written statement that goes into more detail. I'll just try to hit some of the highlights in the time I have. As you mentioned, there is a long history of family separation and cultural suppression that led to ICWA, the boarding schools, the Indian Adoption Project, where that attempted to adopt children out to mostly white families in the East and Midwest, and of course the removal of 25 to 35% of children from their homes by state welfare systems, 90% of which were placed in non-native, non-relative homes. And so ICWA was enacted, and the philosophy of ICWA, we consider it to be the gold standard, because the principles are that first you try to keep children with parents whenever possible, and at a minimum you keep them connected with their relatives, with their communities and cultures. And we know that at Casey, that we call this the gold standard, because we know that these principles would be good for all children. The evidence shows us that keeping children with parents and ICWA, the requirement of active efforts, for example, is best for children, and that it's much better to help families heal, to help the child, rather than to remove the child. We know that if a child must be removed, that keeping the child with extended family, with kin, is in their best interest. Those placements, the research shows us, those placements are more stable. There are fewer behavioral issues, and it's less disruptive for children. And of course, in ICWA, the placement preferences, relatives have that first placement preference. And then finally, keeping children connected with communities and cultures are good for all kids, and especially for Indian children. And I'll mention, by the way, the extended family concept in tribal communities is particularly strong, and so it's even more of a priority for Indian children to keep them connected. And then keeping them connected with communities and their cultures, we know that if you keep them connected with their community, they'll have a network of caring adults. They'll have more relationship permanency, which is always good. No child ever had too many caring adults in their life. And then you connect with cultures, correct? And by keeping them connected with culture, there's self-worth, there's identity, and all of the benefits, resilience that comes from that. Finally, we know in ICWA, a big part of ICWA is tribal involvement, the role of the tribe in state systems. And the evidence is that early tribal involvement leads to increase and faster reunification, and better connections with family, community, and culture. So tribal involvement, not only from a sovereignty perspective, but also from a best interest perspective, is very important. So we know that when ICWA is applied properly, that it works, that there are higher reunification and kinship placements. There's reduced congregate care. There are fewer kids that age out of homes, but we also know that ICWA isn't always applied the way it should be. We still have disproportionality in terms of placement rates. Native children are still placed nationally at 3 times the rate of non-Native children, and a little over half of the placements are still with non-Native, non-relative families. And so there is work to be done to improve compliance at all levels. And so it's better than 1978, but those efforts need to continue. And then finally, you mentioned the constitutional challenge in the Brackeen case. Obviously, that is a threat to the protections of the Indian Child Welfare Act, if any of those constitutional challenges were to succeed, and even potentially a larger threat to tribal sovereignty if the more extreme versions of the arguments were adopted. And so it's really critical, we believe, for governments at all levels to continue to work together. Federal governments, state governments, tribal governments. We see that happen in many ways, at the state level, in addition to federal efforts. And all those things need to continue if Indian children and families are going to continue to have these critical protections. So thank you. 5 minutes sure goes by fast, but hopefully if I left anything out, I can answer some questions later.
And thank you, Mr. Trover. There will be opportunity to respond to questions as we go forward. Now I would like to recognize Ms. Veronica Kropnik, who is a foster youth advocacy programs coordinator with CASA First. Ms. Kropnik, the time is yours.
Good morning, and thank you so much for inviting me into this virtual space with you all today. I feel really honored to be part of such an essential conversation, especially with the uncertainty regarding ICWA. To make the most of my time, I don't want to spend too much time on the history or the law itself, but rather my own personal story and history with navigating the complexity of the child welfare system as an Indigenous child. I was born Veronica LeClaire Howard, the daughter of 2 vibrant, free-spirited, but also lost teenagers. And from what I can piece together from the fading memory of a toddler, I was a happy and cared for child, being raised primarily by grandparents, great-grandparents, aunts, and uncles. Unfortunately, during the beginning of my childhood, I would watch my parents slowly slip further and further away from their family, their community, and myself, and become completely enveloped in their relationship with drugs and alcohol. What felt like a lifetime later, I learned that these actions were not out of a lack of love or care for me, but a reaction to the pain and trauma they had endured in their own young lives and had kept buried deep inside. At 6 years old, I entered the New Mexico foster care system and became a part of a statistic, another Native child disappearing behind the red tape of child welfare. At 7 years old, I was joined by not 1, but 2 of my younger siblings, and the brief window of my childhood closed as I became the closest thing they had to a parent. At 9 years old, I went to school one day and I never came home. I had been placed in my 7th and final foster home with nothing but what I left with for school that day. And at 10 years old, I officially became Veronica Ray Kropnik. Like many other people who have endured this system, I can pinpoint one day that completely altered my life forever. For me, that day is September 12th, 2005, because this was the day that I became lucky. From that day forward in my life, whenever the subject of my adoption or my time in foster care would come up, I was often met with this phrase, "You must feel so lucky." And each time I would politely smile and nod in agreement because why wouldn't I feel lucky? After enduring 10 years of severe abuse to every part of my being, why wouldn't I feel as lucky as everyone thought I should be? I was given an excellent education. I was brought into a caring and loving and beautiful home with 2 well-intentioned and dedicated adoptive parents. I was given endless resources. So why wasn't it working? At 10 years old, at 12 years old, at 15 years old, I didn't have the words and I didn't have the understanding to explain what was going on for me at that time. Because what no one wants to acknowledge and talk about is the invisible pain. The pain that is hidden behind the laugh or the smile of a child who was so desperate for approval, for love, for acceptance, that I would have done anything, including compromising myself, my identity, my values, my personal experiences. The pain that never actually went away, no matter how many hours I spent sitting across from a therapist, trying to talk myself to wholeness. I spent a lot of time between the ages of 10 to 18 believing that there was something truly wrong with me. Why couldn't I just make it work with this family? What was wrong with me? And in my very darkest moments, would everyone be better off without me? And that right there is the power of the foster care system. It has the power to completely change not how you just see the world, but also how the world sees you and how you see and value yourself. And my value, my self-worth became directly tied to how much I believed my now adopted parents and family wanted to keep me. And with this driving belief, as a child, as a teen, as a young adult, I didn't even realize I was hurting myself, trying to mold into a person that I would never be, and abandoning pieces of myself that were incredibly essential to my well-being and my healing. Instead of finding joy and connection and healing in my identity as an Indigenous person, these were replaced with feelings of guilt, anger, shame, and even embarrassment. I reconnected with my paternal biological grandparents when I was 22, and this is a memory I hold fondly because I remember the warm embrace of my grandfather and him telling me, "Mono, I'm going to live longer now that I know that you're okay." And I believe him. And something with those words simultaneously healed and broke within me, because not only was I loved, but I was fiercely, unconditionally, and wholeheartedly loved, and I had been this entire time. I share this experience, my personal experiences, with you all because the topic of child welfare, ICWA, and the well-being of Indigenous family and children is personal, and it should be. I share this story because I can't turn the clock back and get back the 18 to 19 years with my grandfather, with my grandmother, with my family, no matter how desperately I want to. And I would also like to say that we collectively, not just our Indigenous relatives, need to fight to ensure that these protections like ICWA stay in place so that our families and our communities remain intact. So I appreciate your time and for allowing me to share a small piece of my story. And thank you.
Thank you very much. Next, let me recognize the Honorable Karen Returns to War, who is co-chair of the Northern Arapaho Tribal Business Council. Madam Co-Chair, time is yours.
Dosniaka, na sitna, dilgusi. I said, hello. My Rapo name is Sitting Woman. I currently am the co-chair of Northern Rapo Tribe. I am truly invested in this Indian Child Welfare Act. And the reason being is that my own immediate family has been affected by the Indian adoption that was rampant in 1970s, late 1960s, 1970s. Two of my older sisters and my older brother had their children adopted out to non-native families. Currently, my oldest niece has found us over 5 years ago now, and she's finally met her biological family, which was really great because at the time my mom and dad were still alive, and they got to finally meet their oldest grandchild. Currently, at this moment, I still have two nieces out there somewhere. We don't know where they are, and we hope that we will be reunited with them. I I am the voice for my nieces. And that's why it's extremely important to me. As many have mentioned, the attack on tribal sovereignty through our children has happened in the past. However, it's extremely important. Self-determination for tribal nations is extremely important. We need to have that say what happens to our children. We in the Arapaho way of life, we have rituals, we have traditions, age naming ceremonies, different duties, things that are taught to you as you progress through life. As my father had stated over and over again, there's always 4 ridges of life. From our babyhood into our children, and then over into our adulthood. And then the final heel of life is our elderlyhood. Basnanetana, that's what we call them, our elders. In our traditions, in Northern Arapaho tradition, and many other tribal nations across Indian country, children are sacred. In our language, we express what we say. But that our children are sacred. No one knows how important our children are in our way of life. As many have stated, they are our future, our generation. We teach them our songs, our ceremonies, traditions. That is to ensure that our livelihood as Indigenous people will continue. We as the Northern Arapaho are extremely, extremely blessed because we have many of our ceremonies yet. We have many of our songs. We have all these things, and we want to keep our children within our families, extended families, within our communities, so they may continue to learn these things. Knowledge, traditional knowledge. Traditional knowledge is extremely important. In the Arapaho way of life, with knowledge, you learn personhood. Personhood includes learning about respect, compassion, integrity. In our way of life, the Arapaho way of life, quietness is a tribute. It's also craziness. It seems unreal, but craziness is also a way of our life. I know our allies, the Lakota, they call them Heyokas. Us, we have our craziness is also a part of our way of life. How, if a child is removed from their tribal nations, how would they learn any of these things, these characteristics, these attributes, these things that make them who they are? Not only that, but our language is extremely important. That's what sets us apart from other races. It also sets us apart from other tribal nations. It makes us who we are. Hinane. Batan. Hinane di batana. That means our language, our Arapaho language is sacred. And these are the things that we want to continue teaching our children and surrounding them with. The Arapaho way of life, the Arapaho knowledge. I believe that we are fortunate that we have state legislatures who are willing to open their minds and work with our tribal people, the Eastern Shoshone and the Northern Arapaho, to ensure that our children will continue to be tied to our communities and our Arapaho way life. Thank you.
Thank you very much.
Uh-huh.
Hi, finally, I'd like to recognize Ms. Maggie Blackhawk, who is a professor of law at the New York University School of Law. Professor, you're recognized.
Ranking Member Grijalva and members of the House Committee on Natural Resources, thank you for the opportunity to offer my remarks today. My name is Maggie Blackhawk. I'm Fond du Lac Band Ojibwe and a professor of law at NYU School of Law, where I teach constitutional law and federal Indian law. I also serve as co-director of the NYU Yale American Indian Sovereignty Project, and in that capacity, I drafted an amicus brief in Haaland v. Brackeen on behalf of the Organization of American Historians and the American Historical Association. Brackeen is a consolidated set of constitutional challenges to the Indian Child Welfare Act pending before the Supreme Court. I'm here today to speak to the history of ICWA and the significance of this history for Brackeen. My remarks draw upon the historical research from our brief. In Brackeen, the Supreme Court is asked whether ICWA reaches beyond the power of Congress to enact, whether ICWA commandeers state governments, and whether ICWA is unconstitutional race-based legislation. These questions presented require the Supreme Court to consider the historical understanding and practice of federal and state power over Indian affairs and the welfare of Native children, as well as the historical context leading to the enactment of ICWA. Based on the established research of professional historians, ICWA is simply the latest instance of Congress exercising its constitutionally granted authority over Indian affairs to legislate for the welfare of Native families and children. Native nations exercise a sovereignty over their lands, peoples, and children that predates the Constitution. But under our Constitution, treaties, and laws, Congress too bears vital responsibilities in the field of tribal affairs. The federal government has exercised authority over Native people through its treaty, commerce, and foreign affairs powers since the founding. Indeed, Congress's power has been described as plenary. Native nations were recognized as foreign governments with which the United States would form treaties, and the citizens of Native nations were regarded as foreign nationals. Many of these treaties required general protection of Native people, as well as the specific care and education of Native children. What began in 1802 with Congress's appropriation of funds to private entities for Native education soon grew into a nationwide program under which the federal government established boarding schools. States and local governments were complicit in the creation and operation of boarding schools. They sold land and supplied services to the schools at federal expense. Thus, early on, states came to see Native children as a source of additional revenues, not as a responsibility. In fact, states historically took the position that the welfare of Native people should be the exclusive purview of the federal government. By the mid-20th century, Congress recognized that the boarding schools were a failure. Although state educational and general welfare programs grew rapidly during that period, states refused to provide benefits to Native families and children. They refused to allow Native children to attend public schools without federal subsidy. States argued that they not only lacked regulatory authority over reservations and tribal members, but they also were unable to tax Native lands. In response, the federal government focused on funding particular state welfare programs for Native children, the prime example being foster care through piecemeal contracts with individual states. Although these state-federal contracts prompted states to become more involved in the care of Native children, the contracts contained terms that mandated heavy federal oversight, including federal appointment and funding of state child welfare staff, definitions of an Indian child, substantive standards of removal, as well as inspection and reporting requirements. Over time, as states assumed more responsibility for the welfare of Native children, they began removing those children from their homes at unprecedented levels. States were explicit that the removal was driven by concerns over costs. Native children required far fewer welfare dollars when placed in the home of wealthy foster or adoptive families than in the home of a Native family living in poverty. During the 1950s and 1960s, a terrifying national picture emerged. Native nations were losing children to state welfare systems at extraordinary rates. State governments separated over 100,000 of the estimated 400,000 Native children from their parents and placed those children in homes with no political, cultural, or linguistic connection to their nations. ICWA must be viewed within this historical context. Having failed in its effort to enlist states in overseeing the welfare of Native children, Congress enacted ICWA in 1978 to strengthen the longstanding authority of tribal governments over their own children. The plaintiffs in Brackeen challenge ICWA as unconstitutional, but placed in proper historical context, the constitutional challenges to Brackeen are revealed as unfounded. So thank you very much, and I look forward to your questions.
Thank you, Professor. And let me thank all the panelists for your remarks today, and I appreciate each of you for taking the time to share that, share your experiences with us. I want to recognize the members for any remarks or questions they may wish to ask the panelists, and let me begin with my friend and colleague from Arizona, Mr. Ruben Gallego, who in his capacity on the Resources Committee and as former lead for us on that committee, Indigenous Peoples Committee, has promoted and some very significant legislation. And with that, Mr. Gallegos, time is yours.
Thank you, Mr. Chair. I just want to do a mic check. Can you guys hear me? Okay, thank you. Well, thank you all for your time and perspective on this important issue. And as a strong believer in tribal sovereignty and protections for Native children, I'm glad to be able to participate alongside you in this event. I have a couple of questions for our witnesses, and thank you for that moving testimony to begin with. And it was important for us to hear what we have done as a nation. Ms. Blackhawk, in light of the pending litigation in Brackeen, if ICWA is ruled to be unconstitutional, how would this impact other federal Indian laws?
So there are different ways that the court could rule parts of ICWA unconstitutional, and those different ways could result in a range of different challenges to federal Indian law more broadly. So if the court takes the more extreme position that either Congress has no power to pass laws like the Indian Child Welfare Act, it exceeds its Article 1 capacity under the Plenary Power Commerce Clause power doctrine, it could jeopardize the ability of Congress to regulate Indian affairs. And it could, in many ways, challenge much of Title 25 of the US Code titled Indians. And similarly, if the court decides that after 50 years, the designation of Indian is not a political status, which it has been since the founding and before, but is a racial classification in violation of the United States Constitution, which lists the word Indian in it, ironically. That could also challenge Title 25 of the US Code. But as a caveat, though, keep in mind that Congress has many constitutional powers beyond its traditional power seen over Indian affairs. It has spending clause powers. It has treaty powers. It has foreign affairs powers that are also plenary. And all of those powers could be used to justify much of Title 25, as well as new and innovative legislation to support self-determination and tribal sovereignty.
Well, Mr. Trope, your remarks today mentioned the Indian Adoption Project and the history of removing Native children from their communities. Can you speak to how this history continues to impact Native communities and why it warrants policies like ICWA?
Sure. So I think there are a couple of things that can be said about that. Well, there's probably more than a couple, but I'll focus on a couple. I mean, first of all, the continual impact of these policies over generations has had an effect today. I think you've probably heard of historical trauma, and I think that this trauma continues through families. You have people who were sent to boarding schools who never really learned to parent as they would have in a normal family setting. That sort of gets carried down through the through the generations. And then you have issues regarding that issues that need to be addressed. And I think Veronica talked about issues her family had, and instead of trying to help that family heal, the response was to remove her and have her adopted. And I think what ICWA says, when it's applied properly, is no, what you need to do is recognize this trauma, and you need to figure out how to treat that and how to help that family heal so that the children can stay within that family, within their community, culture, with their relatives, etc. So that's one aspect of it. And I think the second thing is also from a tribal community perspective. They've seen children get lost generation after generation. I once represented the Maine tribe in a case in a South Carolina court, a child that was born in Arizona and was going to be adopted in New York. Now, if that sounds bizarre to you, it is. You should think it's bizarre. But luckily, I was able to get the child back to family in Maine. And about a year later, someone got up and thanked me for the work I did and said, we had lost 2 generations. Our family had lost 2 generations, and we were about to lose a 3rd. And thanked me for not, making sure they hadn't lost that 3rd generation. So I think that perspective from tribal communities and the placement preferences that try to keep children within relatives and within their communities, I think that's how ICWA can help address that.
Well, thank you. And I've run out of time. I have more questions, but I really appreciate everyone's testimony.
Mr.
Yes.
Mayor, if you have additional questions, please, let's continue. I think that.
Oh, okay, that'd be great. I would appreciate that, Chairman. I just have one more question. And so this question is for the Honorable Karen Returns. Many state governments have adopted local ICWA versions, and that reframes the federal legislation according to the state's unique needs. Despite these efforts, can you speak to the importance of maintaining a national ICWA law at the federal level and not just relying on states?
Sure. So regardless whether or not each state continues to devise their own Indian Child Welfare Acts, there's always that potential that it's going to turn around and damage our tribal sovereignty. So I'm glad, I really appreciated Maggie's comments regarding how important federal Indian law is. And also the fact that she mentioned that that Congress really has the authority. We are starting on a whole brand new plate. And because of the things that we did and we got passed there in the state of Wyoming legislature, we have created a task force. So we are just now beginning. And I really can't tell how that is going to go, but I'm glad that we have a seat at the table so that we may be influential and really have the input that the federal ICWA law is placed there in the state of Wyoming law. I am extremely glad that other states are following suit for our tribal people. I do understand that this law could be changed in whole or partially. And the part about the race, I really, as Maggie had mentioned earlier, that the ICWA law is a political status, regarding political status. And for them to interpret it as race, it's really important that that doesn't happen, because it's not going to stop with just the Native peoples, the Native nations. That's going to affect other nations, our Hispanic nations, also our Black American, all other races it's not going to stop there. It's just going to open a floodgate. And so it's extremely important that people in power, the people there in Congress, really step up and do what they can at this moment to make sure that that doesn't happen. I hope I answered your question.
Thank you. I really appreciate it. And I yield back.
Thank you, Mr. Gallego. Appreciate, I know it's a flying day, get into town, but I appreciate you taking the time and joining with us, and your leadership on this issue continues to be needed, and your voice has always been very constant. I appreciate it, all of us do. Let me now turn to my esteemed colleague from Alaska, Ms. Patola. The Congress representative, time is yours, please.
Thank you. Thank you, Ranking Member Grijalva. I really just want to thank all of the people who have testified today. I want to thank the experts for all of your work in protecting the children in Native country. I think for every single human group ever in existence, children are precious. Children are our future. And certainly for Natives, it is no different. And I really especially want to thank you, Veronica, for sharing your personal story, because I think it's very important for people in high places to recognize that we are talking about humans. We're talking about generations and families, and we're all related and we're all connected. And what is good for one family and one tribe is good for all families and all tribes. We're all connected. I have worked as a tribal court judge, and the majority of the cases that we worked on were custody cases and making sure that the children of our tribe stayed within the custody of tribal families. And I really also appreciated the Honorable Karen Returns to War sitting woman's comments about the attributes that make us who we are. And we cannot learn those from a book. We cannot learn those from looking at academia or some other way. And nothing is more important to a child than love. So I don't unfortunately have time. I'm going to have to go to my next appointment, but I really wanted to thank you all for helping us in this critical work. And I'm very concerned about the Supreme Court and what we imagine, how we, there were clues about some other really important court decisions that came out, and they ended up being true. Those predictions ended up being true. And I'm very concerned that the concerns and predictions that we have about ICWA standing may be true within the Supreme Court. And I think it's just that much more important for the federal level and the state level and the tribal level to be all working together to make sure that we're protecting ICWA. ICWA is not working now. After all of these years, it's still not working to its full potential. So why would we undermine it even more? So I unfortunately don't have time to ask you all questions, but I just really want to express my appreciation to you for all of your hard work and the heart that you're putting into all of this work. Thank you.
And thank you, Representative. Appreciate the time. I know the anxiety of being from one place and another place, and I appreciate it. And we're all very respectful of you taking the time, and it's very much appreciated. And your leadership on this issue and the role of Congress in mitigating whatever the Supreme Court does is going to be critical, and we're looking forward to that work. Thank you very much. Let me now take the time to ask some questions that I have. Mr. Thorpe, your remarks today demonstrated that ICWA does indeed serve the best interests of Native children. And with that in mind, I know there's data to elaborate further on how that happens and how support for ICWA is an effective child welfare policy for Indian country. But you also mentioned in your comments that it's still disproportionately the placements aren't there, and that compliance is not there. Could you? And I think the Congresswoman mentioned the fact that ICWA is not working to the full intent of the law as we speak. So could you speak about the compliance issue and the placement issue?
Sure. So as I mentioned briefly, the placement rate nationally for Native children is between 14 and 15 per 1,000. And for non-natives, it's closer to 5. So it's still 3 times the removal rate of non-native children. And non-native, non-relative placements still make up a majority of those placements, somewhere between 52 or 56%, depending on what year that you look at. So while that's less than 90% back in 1978, it's a long way from, I think, where people think this ought to be. Better, and it varies from state to state. Some states do a better job than others. But when you think about, I think, what makes the biggest difference, I really think it's tribal involvement. I think we see that when tribes are involved early in cases, when they receive notice promptly, when they have the capacity to be able to intervene and become involved in cases early, when there are state procedures in place, often negotiated through tribal state agreements, maybe they're in state ICWAs, maybe they're in just sort of policies that the state develops together with the tribe. But I think the more tribes can get involved early, I think the better compliance that we see with ICWA. So that's critical. But there's no magic. I think that's the closest thing to a magic bullet, but even that's not a magic bullet. I mean, child welfare system is a difficult system to impact. And so I think it's a matter of changes in the way the system itself looks at these issues and recognizing that removal is traumatic, recognizing keeping children connected with relatives and culture is in their best interest. And I think the more systems move in that direction, I think the more tribes our involvement and tribal capacity is there to have that involvement. I think the more we can make progress, better ICWA implementation.
Professor Blackhawk, the debate around ICWA and what's in front of the Supreme Court includes a lot of misrepresentations and a lot of assertions. The assertions being that it hurts Native children and that it's discriminatory. And could you respond to those assertions and what I perceive to be misrepresentations of not only the law, but the intent of the law?
Yes. So the Constitution of the United States doesn't say that you can't discriminate or regulate people differently. It actually doesn't have the word discrimination in it at all. Instead, it promises individuals the equal protection of law. And with that, it allows governments to regulate different people differently, especially when it comes to certain political categories and designations. That's long been a recognition, not only of the face of the Constitution itself, but of the Supreme Court in recognizing that being within a citizen or even a descendant citizen or a potential citizen of a Native nation is itself a political category. Governments with whom the United States formed treaties and also treaty substitutes even following the 1871 appropriations rider. And so what we have are government to government relationships with these governments and their children, descendant children, citizen children. And similarly, we have laws all over the country, including the Vienna Convention that requires state governments to behave differently when dealing with dual nationals or children who have shared nationality with other governments. And states have no trouble complying with those laws. Texas has no trouble complying with those laws and understanding that citizenship and nationality are distinct from racial classifications. But when it comes to Native children, when it comes to the Indian Child Welfare Act, instead, what you see are individual plaintiffs and state governments mounting really unfounded and unprecedented race-based claims to use essentially the constitutional values that we have elevated to deal with other constitutional failures like human enslavement and Jim Crow segregation to essentially put forward the American colonial project today, to use the 14th Amendment, the Reconstruction Amendments, to further American colonialism. And so you have some deeply ironic and really problematic constitutional arguments before the court. But I think in addition to that, you have a problematic description of the history of federal and state power. So in most litigation, the Supreme Court likes to assume that most of family law is really something that's always been within the purview of the states. And so the federal government, it seems like it's an odd thing for the federal government to step in and regulate families. But when it comes to Indian affairs, the federal government has always regulated Native families. I think problematically often, but the federal power has been there. And instead, you see state governments refusing jurisdiction over Native families. Refusing jurisdiction, refusing to provide welfare benefits, refusing to support Native families to try and keep them together, refusing to put Native children in public schools like other children, other state citizens. And so you see the states being not only refusing jurisdiction, but also being incredibly problematic once they're even brought in under federal compacting power and funded completely by the federal government. They still see their bottom lines as more important than Native children. So this is not a space where traditionally we think states are the best protectors of families. This has not been true in the context of Native children. And so we need to recognize that the arguments that are put forward before the Supreme Court really overlook this history, overlook our constitutional framework, our constitutional text, the original meaning of our Constitution and the Reconstruction Amendments, and are hugely problematic on many fronts.
And Mr. Thorpe talked about compliance and that the intent and the purpose of the law has not been fulfilled with ICWA in its entirety, its intent. And I mention that because I think discuss for me the point that you made about colonization and understanding that as the basis for this discussion, as opposed to perverting what has been other struggles and other human rights, civil rights issues that this country has had to correct in its history. I think that's an important distinction that is not made, and to make this completely a race-based decision on the part of the Supreme Court goes against that colonization history, if you would.
Yeah, so in an over 3-hour oral argument on Brackeen, no justice, no attorney used the word colonialism or any similar term. And the only justice to raise potentially American colonialism and its mitigation as a constitutional value, as a problem of constitutionalism, was Justice Kavanaugh. And he quickly dismissed that constitutional value of mitigating American colonialism as in tension with, or something to be balanced against, the idea of integration and formal equality, these concepts that I think have been really minimalized and problematically narrowed by the Supreme Court. But these are ideas and constitutional values that were raised to solve other original sins of the United States, that were raised to solve other constitutional failures like human enslavement and Jim Crow segregation. The idea of integration cannot solve colonialism. The idea of formal equality cannot solve colonialism. Taking over, expanding your jurisdiction over polities without their consent is an entirely different constitutional problem than human enslavement and Jim Crow segregation. We have done more things wrong that we need to confront and reckon with and find constitutional solutions to. And so the court can't see that the Indian Child Welfare Act is a statute to deal with American colonialism. Taking away children from other nation states is a broadly recognized tool of colonialism, of imperialism. It's recognized as genocide and cultural genocide. How do you get rid of another nation state that you colonize that won't consent to your jurisdiction and you want their land and resources? You take their children away to where they don't exist anymore. Yep. That is a dynamic that we can't seem to recognize on this court, and frankly.
Professor, and the role of Congress, particularly as we talk about ICWA, is and that legislation that strengthening that and providing the accountability at a national level for that history, I think even becomes more important as the discussion goes forward, because Congress does have that power and that ability, and a Supreme Court decision should not mean that we obliterate everything else that has happened in terms of legislation because of that we do have the power to stand apart and look at the constitutional and the historic implications of what a Supreme Court just did. I mean, we're having that discussion around women's reproductive rights right now, and I think this raises to a level of that should be of major concern in terms of all the ramifications that would follow. It's I think this is it. Well, thank you very much. Let me just real quickly, Ms. Krupnik, thank you very much for taking the time. Is there anything else that you would like to add to sharing your experience, which I think is very profound, very real, and needs to be heard over and over again by everyone. But nevertheless, is there anything you would like to add to any of the comments that you made?
Thank you. I think I just have one last comment, and that would be, I think in all of these conversations, I'm very appreciative to see that there is representation of Indigenous folks from many different backgrounds. That really just brought me a lot of happiness to see that everyone has their own expertise. Mine is not law and or as a tribal leader, but as someone with lived experience in the system. So I would just really encourage that as we take a look at this law, either in Congress, as locally, that we're really including the many voices from our tribal communities to get a full spectrum of experiences so that we can better support our tribal communities. So I'll leave it there, and I really appreciate you, Ranking Member, for inviting me. Thank you.
Thank you very much. And the Honorable Karen Sawar, I just you mentioned something that my mom used to always say to me, is that craziness is part of life, and I didn't understand what she meant entirely, but I think I do now, having been here for a while. But I just want to ask you if there's anything you would like to add to the comments that you made as well.
I do. I just want to remind everybody that's involved that, and I know it's kind of cliche to say that our children are very important, but I just like to elaborate why they're important. A lot of our tribal nations have creation stories in them. Many of us believe, we know that our children, have spirits and souls, but some of our creation stories tell of us as children coming across through the Milky Way. And while we do this, before we get here, we already select our parents. We've already made our selection So when we get here, we already are tied to those parents that we selected. By removing our children from this designated selection, you disrupt that balance of that child's life. And so that's, for me, that really is simple and goes back to being human beings and reflects back to our creation and who we are as Indigenous peoples.
Thank you very much.
Yes, thank you. And thank you for having me. I am honored.
We're honored. Congressman Gallegos, any closing comments you would like to make if you're still with us? Just say that I want to thank all of the panelists today for sharing experiences, expertise. We believe it's critical for us to highlight how important ICWA is to both Indian country, child welfare space, and you've all helped elevate this. Many of us in Congress plan to continue working to better protect and implement ICWA, and today's discussion just further helps us with that effort. My staff will be uploading the panelist remarks to our website so that information is accessible to all who are interested. In addition, today's live stream will be saved on our YouTube page. And let me just say that a lot of discussion in our recent times about the state of our youth as a whole in this country, what the pandemic did and didn't do, the state of mental health, the achievement gap, the less and less attention to our young, and given the history among Indigenous children and young people, that is even more aggravated as we talk across the country. It's more disproportionately negative. And so if we talk about the value of the future and the value of our young, it extends to all children and young people. And where we have a legacy that needs to be dealt with, corrected, and applied equally under the law, then the discussion today about ICWA, the discussion and the pending decision by the Supreme Court all dovetail to this point, that this legislation continues to be important. It needs to be updated. It needs to be strengthened. And irrespective of a Supreme Court decision, that has to be the mission. And I look forward to joining with Indian country, their leadership, and the leadership here in the United States Congress to move an agenda that needs to be finished, and an agenda that needs to be strengthened, not only with ICWA, but in the historic relationship that we have with our Indigenous brothers and sisters across this land. So with that, thank you so much. I appreciated it and learned a lot. Thank you.